In this lecture, you will learn about Washington's cabinet appointments and the Bill of Rights. George Washington was elected in February of 1789. Once in office, Washington acted with caution, knowing that with every step he took, he was setting a precedent and that any misstep could be dangerous for the fragile new government. Washington carried his own reputation for integrity into the presidency and encouraged ceremonial formalities to create respect for the office.
For example, how is it that he should be called? Should he be called His High Mightiness, His Majesty the President, President of the United States of America, or Mr. President? Everything that was a first, and something as simple as his name title needed to be cautionally selected.
Washington chose talented and experienced men to preside over the newly created Department of War, Treasury, and State. General Henry Knox led the Department of War. Alexander Hamilton was selected for the Treasury. And Thomas Jefferson was chosen for the Department of State. Edmund Randolph became Attorney General. And John Jay became the Chief Justice of the Supreme Court. Washington began meeting regularly with these men, thereby establishing the precedent of a presidential cabinet. An early order of business in the first Congress under President Washington was the passage of the Bill of Rights, which 7 states had specified as a condition for the ratification of the Constitution. James Madison pulled much of the wording of the rights directly from the language of various states' constitutions with Bill of Rights. In September of 1789, Congress approved a set of 12 amendments and sent them to the states for approval. 10 were eventually ratified. Significantly, no one complained about the one striking omission in the Bill of Rights, the right to vote. Only much later was voting seen as a fundamental liberty requiring protection by constitutional amendment. The Bill of Rights are essentially the first 10 amendments to the Constitution, officially ratified by 1791. The first through 8 amendments dealt with individual liberties, and the 9th and 10th concerned the boundary between federal and state authorities. We are going to go over these very important amendments. The First Amendment states the following: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, and or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble, and to petition the government for a redress of grievances. Most Americans are aware of the rights to free speech, freedom of the press, and freedom of religion, and the right to assemble and to petition, even if they cannot cite the exact words of this amendment. The First Amendment guarantee of freedom of religion has two clauses. The Free Exercise Clause, which allows individuals to practice or not practice any religion. And the Establishment Clause, which prevents federal government from discriminating against or favoring any religion. This clause was designed to create what Thomas Jefferson referred to as a wall of separation between church and state. Although the rights to free speech and freedom of the press are established in the First Amendment, it was not until the 20th century that the Supreme Court began to explore the full meaning of these guarantees. In 1919, the court ruled in Schreck versus the United States that the government could suppress free expression only where it could cite a clear and present danger. In 1990, in Texas versus Johnson, the court ruled that flag burning is a form of symbolic speech protected by the First Amendment. The Second Amendment states that a well-regulated militia being necessary to the security of the free state, the right of the people to keep and bear arms shall not be infringed. Fear of a standing army under the control of a hostile government made the Second Amendment an important part of the Bill of Rights. Advocates of gun ownership claim that the amendment prevents the government from regulating firearms. Proponents of gun control argue that the amendment is designed only to protect the right of the states to maintain militia units. In 1939, in the United States versus Miller, the Supreme Court ruled that the Second Amendment did not protect the right of an individual to own a sawed-off shotgun, which it argued was not ordinary militia equipment. The Third Amendment states the following: no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Ironically, the Third Amendment was very important to the framers of the Constitution, but today it is nearly forgotten. The philosophy of the Third Amendment has been viewed by some justices and scholars as the foundation of the modern constitutional right to privacy. The Fourth Amendment states, The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by an oath of affirmation, and particularly describing the place to be searched and the persons or things to be seized. In the years before the Revolution, the houses, barns, stores, and warehouses of American colonists were ransacked by British authorities under the writs of assistance or general warrants. The British thus empowered search for seditions material or smuggled goods that could then be used as evidence against colonists who were charged with the crime only after the items were found. The first part of the Fourth Amendment protects citizens from unreasonable searches and seizures. The second part of the Fourth Amendment defines the procedure for issuing a search warrant and states the requirements of probable cause, which is generally viewed as evidence indicating that a suspect has committed an offense. The Fifth Amendment of the Constitution states the following: no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The Fifth Amendment protects people against government authority in the prosecution of criminal offenses. It prohibits the state first from charging a person with a serious crime without a grand jury hearing to decide whether there is enough evidence to charge a person with the crime, and second, from charging a person with the same crime twice. The best known aspect of the Fifth Amendment is that it prevents a person to being compelled to bear witness against himself. The Sixth Amendment states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The 7th Amendment states that in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. This amendment guarantees the same right of trial by jury as it was guaranteed by English common law in civil trials. The role of the judge was to settle questions of law, and that of the jury was to settle questions of facts. The amendment does not specify the size of the jury or its role in a trial. However, the Supreme Court has generally held that those issues should be determined by common law of 1791, which stated that a jury consists of 12 people, that a trial must be conducted before a judge who instructs the jury about the law and advises it on facts, and that a verdict must be unanimous. The 8th Amendment states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. The 9th Amendment states that the enumeration in the Constitution of certain rights shall not be constructed to deny or disparage others retained by the people. Some Federalists fear that inclusion of the Bill of Rights into the Constitution would allow later generations of interpreters to claim that people had surrendered any rights not specifically enumerated there. To guard this, Madison added language to become the 9th Amendment. The 10th Amendment states that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The Anti-Federalists were especially eager to see a reserved powers clause explicitly guaranteeing the states' control over their internal affairs. Not surprisingly, the 10th Amendment has been a frequent battleground in the struggle over states' rights and federal supremacy. Generally, the amendment is held to protect the rights of states to regulate internal matters such as local government, education, commerce, labor, and business, as well as matters involving families such as marriage, divorce, and inheritance within the state. Together with the Declaration of Independence and the Constitution, the Bill of Rights helped to define the American political system and the government's relationship to its citizens. That is all for now, but stay tuned for the next video lecture in which you will continue to learn about the early republic.